All right, if I can have your attention, we got all the members here. We're a couple of minutes late, but we'll go ahead and get started as close as we can. This is the first meeting of the Constitutional Law Subcommittee, as it is newly organized. We have 4 bills on the agenda. They all deal with the Ethics Commission. Today, we have asked for I guess it's ETV or the State House to broadcast on our internet streaming video the meeting. We're not going to do that at every subcommittee, but based on the attention ethics has gotten over the past year, and based on sort of the public interest in the proceedings, we wanted to make sure we were as transparent as possible. I'm also going to ask the folks who testify, I'm going to give you the opportunity to be under oath. I'm not going to require it. You don't have to be, but I'm going to give you the opportunity to be sworn in so that if you want to give your testimony in that way, you can. And I'm going to ask the members of the subcommittee for today, any votes that we take those and record them. I don't know that'll be the practice on every vote, but on this bill, these bills, as it deals with the ethics and the amendments, I am going to ask everybody to have their votes recorded. The first, Representative McLeod. As you might recall, the rule regarding swearing in witnesses did not pass the House, so that's not a House rule. It is up to each subcommittee chairman who takes testimony to. It is statutory on the Oversight and Accountability Committee, but not on the other committees. But if I'm wrong, we're going to give you the chance to testify, and Representative McLeod is going to hand me that statutory authority after this meeting. Then we'll have a new policy. First bill on the agenda is House Bill 3184 of the State Ethics Commission. This was filed by Representative Pope and many others. There are several people signed up to speak, but what I would like to do is recognize Speaker Pro Tem Pope and have him explain what his bill does exactly. Representative Pope.
Thank you, Mr. Chairman, and again, I'm here in my capacity as sponsor of this bill. As you recognized, I am no longer on the Constitutional Law Subcommittee, so I'm here merely as a presenter, and I thank you for allowing me to sit up here.
I did try to count your vote as I anticipated how this might come out.
Well, I appreciate it. Gentlemen, this particular bill, as you're aware, we've had the ad hoc committee of the ethics committees that have met in the off season, and this particular bill, is one piece of many pieces. We're not doing an omnibus bill, but this particular bill is about retooling the State Ethics Commission to bring the legislative and judicial branches also under the State Ethics Commission. Basically, what we would do is recompose the State Ethics Commission, and the whole goal of this is independent investigation. It's to have we've heard it 1,000 times, Fox Garden, the hen house. What I envision would come from this, and it'll be kind of a work in progress once it happens, is you would retool the State Ethics Commission and having executive appointees, legislative appointees, judicial appointees, and then that body would act very similar for you guys, and of course all members are attorneys. The Office of Disciplinary Counsel, you guys are aware of that deals with the judges and deals with the attorneys now. It would function very similar in that they would receive the information, investigate the information, have a probable cause type threshold. If that probable cause was reached, much like we do in our committees, much like they do at the Ethics Committee now, and they do with the judiciary, I believe, it would then become a public issue. But the balance there is it allows folks, it allows a thorough investigation without using that system as a political attack. So it filters out the appropriate things by a neutral third party, neutral third body. And then if it is to go forward once the investigation is complete, if it's a criminal matter, it would be referred to the appropriate prosecution situation. If it was merely administrative or civil or whatever we want to call non-criminal ethical violations, it would be referred to the various bodies. In other words, it would go to the courts, or it would go to the State Ethics Commission for the executive branch, or it would come to the House or Senate ethics to be presented. I envision that what this would do, as you're aware, I served on the House Ethics Committee before. what I envisioned happening and what I thought the weakness was we had is we didn't have one, we didn't have independent investigation. Two, we didn't really have investigation. No disrespect to the folks that tried to do it, but it was staff members. So you'd have a full investigation, much like when I was solicitor. SLED investigates, they bring it, then the bodies would hear it, but they would hear it in an open fashion. In other words, you know, like House Ethics could hear it, but it would be open, it had been thoroughly investigated and be openly presented. And that's what would happen for each branch of government. So what I think this brings us is the independent investigation, while recognizing the concerns. Haley v. Rainey actually fleshed out that one sentence in the Constitution that talks about us policing ourselves. It actually even strengthened it, I believe. So I think the arguments you may hear about us being required to somewhat police ourselves, there may be some truth there, but I think the way this is structured, it gives you the independent investigation you need while allowing those bodies to still retain ultimate decision-making authority. Likewise, I think Senator Delaney, I've heard that in the hall, Chairman Delaney is going to have an amendment. I think what we recognized as we worked through it, and what I'm presenting to you came from the ad hoc committee that I chaired. But what I see happening is the model that I've always envisioned, and knock on wood, I've not had to appear before the Office of Disciplinary Counsel that deals with judges and attorneys, but the process I envision for all of us, be it executive or legislative, judicial, is very similar. So I think ultimately we may be using the ODC and Lee Caggiola's office as a model for how we go forward. I think what we will do also is make some changes, and that would be with the Representative Chairman Delaney's amendment that would address and recognize the unique nature of the judiciary while still putting some independence into that too, that would allow that to be governed in a manner that allows it to flow and proceed appropriately while giving the public confidence back they need.
Do any members have questions for Speaker Pro Tem Pope?
After my acceptance speech for pro tem, they say I go a little long, so I tried to hit two birds with one stone there.
And everyone here appreciates that effort. I did have the gavel ready.
Are we authorized to ask him any questions now, or should we wait till we hear from the public?
You can ask him now. Representative McLeod.
Well, I wanted to get a little better understanding. So basically, upon a finding of probable cause, 30 days after that, the documents relating to that would become public?
Yes, sir, and the process would become public. And again, the probable cause threshold placing there to try to strike that balance between, you know, we keep hearing, let's don't have witch hunts. Let's properly vet what we need to, but not have witch hunts. It is basically the same standard that the Ethics Commission uses now and that we use here, but we want to have it done by an independent third body to give that extra layer of comfort.
And that would apply to House and Senate members, all judges, and all other public officials?
Yes, sir.
Thank you. I also want to ask about an action may not be taken out on a complaint filed more than 4 years after the violation is alleged. Did your committee discuss maybe 6 years?
You know, that component was, as you're aware, is the existing component, but 6 years versus 4 years did not really come up. Now, I will tell you, and I have to be careful because what happens in our Ethics Committee now that I've served on before, but those issues have come up before, the statute of limitations and what would bridge that gap. So in fairness, our subcommittee did not get into, you know, a suggestion or to expand that time, but quite candidly, I wouldn't be opposed
Well,
to
as
it.
an ex-solicitor, would you suggest that 6 years would be better than 4?
Well, in fairness, as an ex-solicitor, of course, we didn't have a statute in criminal, so it allowed us to do whatever the proof would bear out. So, you know, I'm not opposed to a longer period of time. I think the balance we strive to reach is to recognize you know, have people, citizens serving, but also to ferret out illegal or you know, of course, if it's illegal, then it's no statute of limitations. But if it's administrative, then that 4 year four-year statute would apply. In fairness, I don't know where the 4 years came from, initially, if it was arbitrary, or it was because of terms, if that was why it was brought. But again, in fairness, it didn't come up in that committee. But personally, I'm not opposed to any length of time.
I would just suggest to the committee that we think about 6 instead of 4, since things have happened that have a long time before we catch up with them.
Yes, sir.
Another thing I want to ask about is, a couple of places where it says, if the commission finds that there's probable cause to support the existence of criminal intent on the part of the respondent. Well, that would be under the judge's part and the others. On page 19, for instance, number 4, I read that related to judges, judges. But I thought that probable cause was a finding which kind of roughly means that someone probably did it.
And then means more likely than not. But what you just said.
So I'm saying that probable cause really doesn't require that you conclude that there was criminal intent. You concluded as probable cause that it was a violation.
Yes, sir. I think what that's addressing, not as far as the mens rea, I don't think that was the issue in there. I think the problem we were running into that we're trying to conquer, and it kind of surprised me, even when we met and we're talking about ODC, as a prosecutor, nobody had to tell me if I saw crime what to do about it. But I can't say that there was a thing in the statute that said, Tommy, if you see crime, prosecute it. Well, what I think we've seen with these bodies is there's like a question mark. You see criminality, we're not really equipped to deal with criminality. So if it's criminality, you're supposed to be farming it out to the prosecutors, to where it needs to go and let them make those determinations. So if there's criminality that arises, then I think that's what that language is trying to do, is say that's where it goes to your Attorney General, to your solicitor. You got that second?
Okay. So you're saying that in order to sort of bifurcate this matter properly, there need to be a finding of probable cause of criminal intent in lieu of probable cause of a criminal violation.
And let me pull to make sure that I'm on the same sheet of music.
I'm
You
on,
said-
still on page 19. Subsection, line 12.
Yes, sir. I think what that's trying to do is codify that, and maybe it's inartfully phrased, but the idea that if it's crime, that's not our bailiwick. And I'm saying the ethics committee, the House Ethics Committee, if it's crime, it should be sent in another direction. Now, the positive here, and again, part of this, at least my influence on this was drawn from my experience with the Ethics Committee, is that we want to make sure that folks that are not equipped to deal with criminality, not prosecutors, not investigators, are not making not criminal decisions in reference to criminal activity. Because again, that oftentimes it was a chicken and the egg issue with the Ethics Committee that I served on. We're there dealing with laws that can be both civil or administrative and criminal with our ethics statute, and that was the difficulty. We just want to make clear that if it's crime, it's time to send it to the prosecutor, and that's again the goal there.
Okay, I would say that it seems to me like if you say existence of criminal intent, that's too high a bar. We need to say that there's probable cause to support the existence of a criminal violation.
Or action, I'm sorry.
I mean, I didn't make this stuff up. I learned this at the jailhouse, and I learned this as a magistrate. And I think if
I think one thing, I agree with you. I agree with you in that section. I will note that this is the The amended language that we're not talking about yet apparently is going to address that somewhat too. Because this, as you noted, was the judicial section. The new language will indicate reliable information indicating the judge has violated the criminal laws. So you.
Well, that's the amendment that's coming up?
Yes, sir, that was what was just
And
handed
so
to you.
that's in there under the judges section, and then it's also in there under another page,
That's the referral section on the
like
other section.
16, I think. Yeah, on page 16, line 18, where it says, support the existence of criminal intent. And that's,
Well, I know I can't make motions with this body anymore, but I would agree that the new language, because what I've always envisioned, and you're right, I take it with the prosecutor's eye, what I always envision, if there's criminality or the appearance of criminality,
Yeah.
let the guys who deal with criminality deal with it. So I agree. And I see what you're saying, that you believe that if I'm having to show criminal intent, I've amped up the standard up to here
I concur.
instead of here. And so again, I'm not on this committee, but as far as that section, I have no problem with marrying that language to match the chairman's amendment.
all right. I think that's all. Wait a minute. That's all the questions I have, Mr. Chairman. Thank you for your insight.
All right, we have some folks that want to testify. Lynn Teague has signed up first. Lynn, you want to be heard on both at the same time? Come on up. So 3184 and 3185. And I suspect shortly we're going to combine those two and deal with them as one entity for today, because some of the amendments that I've seen being passed
Okay.
around deal with both of them at the same time, so.
Great.
Yes,
And should
ma'am.
I throw in 3188 while I'm at it? Or we'll hold that one?
Well, why don't you go ahead and give us all your comments?
Okay.
Save you another trip.
All righty. Thank you very much for hearing me today, and I will be brief because some of you have listened to me an awful lot in the past couple of months. On 3184, the main point I wanted to raise was on inclusion of the judiciary. The league agrees in principle that everyone should be subject to independent investigation, that it's a good thing. We hope that there will be some flexibility if that appears likely to be a major obstacle to passage. On 3185, we note that the bill sends cases to the magistrate's court. When we looked at that more carefully than we had in the past, we thought of the issues that arose this past summer, that even a circuit court judge apparently has some difficulty with ethics law. And a magistrate's court might not be well prepared to deal with these issues, and it might be preferable to send it to general sessions. And on 3188, this is not so much a problem with this particular section, but it interlocks with another. It permits donations from caucuses and parties, and that in turn leaves the door open for donations from lobbyists to those caucuses and parties, who then donate to candidates. We don't believe that that chain of events should occur. The exclusion, we're not objecting so much to the exclusion of caucuses and parties taking donations in general, but we are raising the problem of their taking donations from lobbyists and lobbyist principals. And other than that, I just want to thank everyone for doing a really great job. I know an awful lot of work has gone into these bills, and we really appreciate it at the League, and we look forward to progressing with this. Be
Thank you,
glad
Ms.
to answer any questions.
Thank you, Ms. Teague. I do have one. When you're talking about sending some of these cases to the magistrate's court, that is in the criminal section of the new bill, and that would be for the lower level prosecutions that would be handled by a prosecutor. So a solicitor would be there handling that in magistrate's court, similar to other misdemeanors, and it would be consistent with the rest of the criminal code and the statutory scheme. Was that a big problem for y'all, or do you just Because it was,
It isn't one that would lead us not to support the bill.
Okay.
None of these are. These, we've had ample opportunity to tell you about our major concerns. These are tweaks that we wanted to raise here in subcommittee at this point.
okay, and I know I have seen, while I'm sitting here, several amendments related to the judicial branch, and I think we'll be talking more about that, so don't leave.
Right.
That may alleviate the concern that that's a problem for the bill going forward.
Great.
Does anybody on the subcommittee have a question for Ms. Teague? We're working hard up here.
I know it. I know it.
Thank you for your comments. I'm going to take a moment, recognize a couple of members of the House that are here. Stephen Goldfinch is here. Stephen, thanks for coming in and listening. Representative Finley, who has been, I don't know if neck deep in the ethics reform bills would be a fair description. I think you're not over your nose where you can't breathe, but it was pretty close. Appreciate you coming. I know one of your bills is on here. Since Ms. Teague has talked about it, do you want to respond, give the subcommittee a brief description of the campaign contributions for non-candidate committees, or you want to wait till we get to it?
I appreciate it, Mr. Chairman, but it looks like y'all are in the midst of, for those of us who are not in the legal profession would call it making sausage.
Right, well, don't leave, because we're going to get,
No, I'm
we're gonna
not.
get to it
No, so-
shortly. All right, does anybody else want to be heard on 3184 or 3185? I know there's some folks who want to talk about the amendment that hasn't been offered yet. But I think, all right, so the amendment, as I understand it, that's getting ready to be offered deals with both 3184 and 3185. So I would ask, Representative Delaney moves for unanimous consent to combine both 3184 and 3185 for the purpose of offering amendments at this subcommittee hearing. Is there an objection to that? Hearing no objection, the first amendment on the desk is Representative Delaney's amendment dealing with 3184, and Representative Delaney is getting ready to explain his amendment to us, but I believe it deals with how we handle complaints related to the judicial department in the independent investigations of those complaints. Representative Delaney. Yeah, we're on your amendment.
Okay, Mr. Mr. Pope really put this amendment together, but since he's not on the committee, I'll make it for him. But what this amendment does is it creates a commission, a new commission on judicial conduct. It takes the judges out of the commission which deals with, it separates it out. Of course, separation of, not to have a separation of powers problem, or not to have that argument. It separates out where the executive branch and the legislative branch are governed just like we've been talking about. And then it sets out the judges with a new commission on judicial conduct. And rather than that commission be exclusively determined by the court and controlled by the court, it will now be controlled by a 26, it'll be a 26-member commission, which will be appointed by the Supreme Court, the General Assembly, and the governor as follows. The Supreme Court will have 10 members on this commission, 8 of whom will be judges from the larger courts, the circuit court, the family court, or master in equity, and 2 shall be judges from the magistrates or the municipal courts or probate courts. The President of the Senate shall appoint 4 members, and 2 of whom must be regular members of the South Carolina Bar appointed from the state at large, and 2 must be from the public members appointed from the state at large. The Speaker of the House will appoint 4 members. 2 will be regular members of the South Carolina Bar appointed at large from the state, and 2 will be members from the public. And the governor will appoint 8 members, 4 of whom must be regular members of the South Carolina Bar appointed from the state at large, and 4 of whom must be public members appointed from the state at large. And they'll serve for terms of 4 years and until their successors are appointed. And it basically preserves the ODC as it currently is, but it expands the investigatory commission. It's no longer within the exclusive domain of the court. There'll be appointments from the General Assembly and from the governor, as well as from the court. If y'all want to talk about it, we can talk about it.
So if I'm following you along, we're going to set up, has been an independent investigatory body for the courts. We're going to have outside folks, non-judicial members on there, but it's going to be separate because they really deal with separate issues. The judicial conduct obviously would be separate from the Ethics Act in a lot of different ways. Is that
That's correct.
okay? Any other comments or questions from the subcommittee? Representative Pope.
As I alluded to when I was talking about the amendment that we couldn't talk about before, didn't talk about yet, the whole structure already exists under our court system. And I think the very vision we have for our Ethics Commission is already happening for attorneys and it's happening for the judges. The missing component is the independence of the body that makes those decisions. Same kind of deal that we're addressing here. And so what this is going to do, and I think Patrick and I were talking, we would marry up the language, make sure it's similar, but you're having all 3 branches of government pick the Ethics Commission. We're going to have all 3 branches of government picking this commission to do the same thing. The concerns, as you noted, Mr. Chairman, is there are different, the whole different set of canons that the judges also deal with in addition to we as elected officials deal with. And I think this will allow that scrutiny and that skill level from that committee to remain where it needs to be while giving the public the comfort that for the 400th time, Fox Garden, the hen house, you're not having the Supreme Court, the Chief Justice, decide who's going to be on this committee and it's all closed in for judges. We're going to open it up for them just like we're opening it up for the other 2 branches of government. And so I think it's a good balance that deals with the constitutional issues. And again, the model that they have now is what I hope the model will be for our Ethics Committee. Again, you guys are familiar with it based on your legal practice. Hopefully, that's what we're looking at there. So that was the intent of this.
Representative McLeod.
Well, I'm certainly going to defer to the wisdom of Chairman Delaney and the remainder of the committee, but nonetheless, I would simply say that the public views legislators, judges, and everybody else who's in office as public officials, and they want them treated alike. And I can assure you that this isn't any fun for me to talk about, but they want the same outfit to handle all public officials. And that was the beauty of the bill that the House passed last year, which the Senate would not accept. I reintroduced it again this year because I knew, it was my opinion, that we could not do any better than we did last spring when we passed the House Ethics Bill. I respectfully disagree with the basic understanding that we ought to have a separate and distinct ethical conduct commission for members of the judiciary. And I just respectfully disagree. But I understand that there's been some arrangements made, and for that reason, I'll acquiesce to the committee.
Thank you, Representative McLeod. Any other comments from the subcommittee members? All right, does anyone want to be heard on that amendment? Lee, this will be your chance if you want to say anything about the amendment. You don't have to. I just had you written down.
Thank you. I appreciate the opportunity to be heard. I'm Lee Caggiola, Discipline Counsel for the Supreme Court. And as you know, we've been talking to you a little bit about the way the procedures are held for judges. I think that, first of all, I think the amendment that allows the House, the Senate, and the governor to appoint members to the commission is a good idea. And I think that's helpful for the public to understand that there are a number of entities that are involved in creating that commission. I do think it's important that the Supreme Court continue to have sitting judges on the commission, as they're the ones that do this on a day-to-day basis and are able to be appropriate adjudicators for the issues that come up. The procedures that are set up originally through the Rules 502 for judicial discipline are well-formed and require thorough investigation and transparency when, in fact, there are matters of misappropriation, misconduct on the parts of judges. The ability to be able to take these matters, review them, and in some cases have some fairly sophisticated investigation by members of the Office of Disciplinary Counsel, I think ultimately the public can understand that any misconduct, any serious misconduct at all, is made public, whether it's through an agreement with the judge or through a hearing in front of a panel of the commission. And that's what the public wants. They want to know that if members of our judiciary are committing misconduct or violating those canons of judicial conduct, that they are made aware of that and they're public. So I think the way it's being done is indeed appropriate. I think it's thorough, and I think it's transparent. And we would ask this subcommittee to consider this amendment in its entirety. And I guess the last piece is, there is no question if criminal conduct is discovered in the course of an investigation, we agree that that should be referred to law enforcement, the Attorney General's office, the U.S. Attorney's office, wherever the appropriate location is. And so we're fully supportive of that, and in fact have looked at including that, implementing that in our rules as they've stood so far. So we are completely in agreement with the amendments that have been suggested today, and hope that the committee will vote to accept them.
Ms. Caggiola, thank you for your comments, and we appreciate y'all's engaging in this process and discussing ways to make the system better and improve it, but at the same time recognizing that we should keep the things that are really working well, and the bar and your office have done a very good job, and we appreciate all the work that y'all do. Does anyone have any questions at this time about the amendment? Thank you.
Thank you.
All right, so the pending question is the adoption of the Delaney Amendment, and we are going to ask y'all to raise your hand if you're for it or against it, so we can record that. All those in favor say aye. All opposed? The ayes have it. The next amendment, and it's like it snowed amendments up here, so give us a second. We're making sure we got the vote recorded properly up here. We're doing this one first. All right, the next amendment, the two amendments are just this. The Are these not all separate amendments, or just one big amendment? No, this is one big. All right. All right, here's what there were several amendments that were proposed. As y'all know, this is the product of an ad hoc committee that's come out of several months' worth of work. Representative Pope and Finley were instrumental in producing a lot of these bills. Today, we've received several amendments for proposed changes to that bill, some of which may be very meritorious, some of which may not. I'm going to tell y'all what the amendments are. I'm going to make them available as amendments, but I anticipate making a motion to hold those amendments until the full committee, so everyone will have an opportunity to review them. We can look at them. There's going to be amendments at full committee, and then we can deal with these specifically. In the bill, we added section 813.15.15, which deals with failing to make a required report that has the effect of concealing a violation of the chapter and making that a criminal offense. So failing to file something that conceals a violation of the chapter would be a criminal offense, and that's in the bill now. There's an amendment that would graduate the offenses based on how long you wait and how many times you fail to file. I think some members at least want to look at what that graduated time frame was and how you might get, just to make sure that we're not going into the next reporting period where you miss one report, you file your second report, and then you think you've complied, and 3 years later you're committing a felony because you missed the deadlines. Several other ones relate to who you send if there's evidence of a criminal conduct, who you send it to, whether it's a solicitor or attorney general. There's a question of is it evidence of willful conduct or evidence of criminal intent? And I think that probably we ought to get this subcommittee and the committee the definitions of those two as they are amended in the new bill to make sure we're requiring the reports that we want to require. There's an amendment that would require a brochure, which I think is a great idea, and I'm in favor of that and think there ought to be a lot of education of public officials about what their requirements are and when they're supposed to report and when they're not. And I'll be supporting that one for sure. And then there's a designation of which county would be the site for any criminal charges to be brought, which would be Richland County. That's the way it is now. And I think it adds that you could bring the violation in the county of the alleged violator. So you would open up the venue. There was at least some concern about venue shopping and where you would go, and I think that's worth spending the weekend researching. So with that being said, I'd ask staff to put that on the website so everybody can look at it. I'm going to sponsor those amendments at the full committee. I think the full committee ought to talk about them, but I am not going to offer them today so we can move the bill along without getting hung up on the definitions contained in those amendments. Are there any other amendments to 3184 or 3185? Representative McLeod?
Mr. Chairman, I thought we'd kind of come to an understanding on the concept of criminal intent versus a criminal violation, and that's been eliminated with respect to the judges because we've moved beyond that. But with respect to everyone else, I think it's page 16, just a second. Yeah, page 16 of 3184, line 18. And that's where it says, if the committee finds that there is probable cause to support the existence of criminal intent. And under the amendment to, which I thought was Mr. Delaney's, I might be wrong, the second amendment, section 2 of the piece of paper that says amendment to 3184, subsection F, it seemed to me like we ought to proceed and adopt. I think that's what.
Show me what
Right
you're
there.
talking about.
That's
This
stuff-
one.
Right. Is that Mr., is that yours?
All right, so Representative McLeod moves for unanimous consent to offer all right, we're gonna So, to avoid having some of the problems with unwritten amendments that we have had in the past, staff is now going out to draft the McLeod amendment, which we, if I understand it correctly, would make the language in the bill consistent so that if there's evidence of a willful violation of the rules, that would be reported to the Attorney General's office. That is a portion of the big amendment that was offered that'll be put on the website, and we'll look at it, the full committee, but she's going to get that drafted now. While we're doing that, if the committee's inclined to do so, I would suggest Speaker Pro Tem Pope talk about 3185. Since we've combined those two, go ahead and tell us about that bill.
Yes, sir. In its simplest form, 3185, what we always hear is the concern that the ethics bills are both criminal and civil, and when do they proceed civilly and when do they proceed criminally. Also, there's a number of things that are wrapped in the ethics code that are just basically theft crimes. You know, if I took $2,000 from my trust account at law firm, it'd be, breach of trust. But if you wrap in the ethics laws, it becomes a little more convoluted. So what we did in our subcommittee is met with the Attorney General, a number of solicitors, including Solicitor Scarlett Wilson from Charleston, Solicitor Pasco, and went through the process by which they prosecute these charges and what they look at. And that helped us in, one, dividing them out, and two, putting some tiered penalties, much like you'd seen in some of the other areas, the tiered penalties, just like it would be if it had been a larceny crime. The other thing they did is we discussed at length, and Herb Hayden was involved too from the Ethics Commission, when they decide to move forward, when they don't. And Mr. McLeod, actually, the language you talked about, the willful conduct aspect, was one thing they looked at in deciding the difference between a late filing and a filing that you're doing to cover up or to cover some criminality. So they provided some willful violation language that would be added also, and that the willfulness would be what brings it to a criminal penalty versus an inadvertent filing or late filing. It said willful mean the act is intentional and knowing as opposed to inadvertent. However, proof of evil intent or knowledge that the law is being violated is not required. Again, then we did some penalties for breaches of the ethical standards, and penalties for filing, late filing. Particularly, the prosecutors were particularly concerned if you're late filing, which arguably is not as significant, but you're really doing it to cover up, something more egregious. So the gist of this bill is trying to put criminality in the criminal section, leave the administrative, civil things in the civil section, give a little more clarity, so when we have these bodies, they would be tackling the civil administrative things, and the criminality would go to the prosecutor.
So Representative Pope, in other words, the technical violations where you make a mistake in your reporting, we're going to say those are civil in nature and they'll be handled in the ethics committee. And then those things that are criminal, where you're violating the law, like stealing money,
Right.
it's going to go to the Attorney General.
You hit it, stealing regardless whether you're in office or not, and that's exactly right. And what it's doing is allowing an independent body to be that filter. So going back to what Mr. McLeod was saying about the public and their trust in the system, I think some of the people that spoke said that also. I think this will address that, so we can get on when they need to prosecute somebody criminally, they do, but when we need to deal with administrative, we're comfortable that a third party has looked at it. That's why these two bills go together.
All right, any of the members of the subcommittee have any questions for Speaker Pro Tem Pope about 3185?
Got one.
Representative McLeod.
Mr. Pope, I noticed you got, for a public official who is participating directly in procurement to resign and accept employment within 1 year from the date of leaving office with a person contracting with the government entity if the contract falls under the public official's official responsibility. And that's, just a minute. That's on page 6, line 21 through 28. And I wanted to inquire whether there was any conversation in your ad hoc committee about whether 1 year is is inadequate. It should be more than 1 year. Or maybe it might want to be 6 months. We're just trying to figure out what is an appropriate time frame to protect the public interest. Seems to me like 1 year is not enough.
The 1 year actually came from some other language in the lobbying statutes, when they talk about how long before you can do certain things. And it, 365 days may in fact be an arbitrary date. What we were trying to do is leave some distance. As you know, I think of everything as a prosecutor, being able to prove that nexus, with some reasonable certainty that the real reason you left was because you had this sweet deal you'd cooked up while you were in the legislature. And that's what we set to avoid. But in fairness to your question, the 1 year came from language that I thought more learned men than I may have thought about in the past on why they did, the lobbying bills in those sections like they did. So that, again.
So we kind of followed the pattern that we followed in the past.
Correct. That's one of my mental illnesses, that I like everything to match up. That's why I like the civil and the criminal to be split out and matched up too.
All right, thank you, sir.
Any other questions? Does anyone in attendance want to be heard on 3185 as it relates to separating out and identifying and providing penalties for criminal violations of the Ethics Act? Any other discussions by the subcommittee? Representative Smith.
Thank you, Mr. Chairman. Are we changing any of the penalties in this? I know we're separating them out, but we're making changes to the penalties.
I believe they're graduated in the bill. They're now going to be graduated as opposed to one penalty. There'd be, depending on the level of the violation.
Okay, so we are.
Could be
so
as
there's
low as a
potential for a
misdemeanor.
lesser violation.
Yes, if it's, I think one of them was under $2,000 would be a misdemeanor, triable in magistrate's court, and it graduates from there.
Okay.
Representative Smith, what we tried to do, and it goes back to kind of what Mr. McLeod and I were talking about, if something looked like a breach of trust, but it was in our ethics laws, then
Right.
what we tried to do is look over at breach of trust, make sure that matched up. And so that's where those came. There are some areas that have, and Patrick was working with us when he was on judiciary, there's some
Sure.
areas that will have increased penalties. There are also some areas that will have a greater variety of penalties. Again, you know, I've said it 14 times now, I always think as a prosecutor, and you know in defense work, there's some times when the lower level may be appropriate based on the facts and circumstance, and the higher level, we want to make as much available. Again, I wanted it to mirror the criminal justice system as much as possible, on both the high and the low. So that's what we shot for.
Okay. And you're talking about criminal penalties now, which wouldn't be handled by the commission anyways. We're talking about what would be before a prosecutor in determining whether or not to plead down to something lesser or to
Correct,
resolve
it would give all the options that
Yeah.
you know in the prosecutor's basket, but again, what we had to try to do, you know, everything was coming through to this ethics commission, and there wasn't like a gate to
Right.
send it criminal, and so what we're trying to do is both in the law and in the mechanics, is send it criminal or keep it civil as the case. And you know, sometimes they overlap, there may be some parts that lead to the other.
Right.
But that's what we were trying to do.
So they can retain jurisdiction of ethics violations or civil issues and then refer what they believe to be criminal over. And you all set out we're about to set out the penalties for those.
Absolutely.
And they follow what has been done previously on similar charges in criminal process.
And what we wanted to make sure is, again, there wasn't a chance that the criminal justice system needs to run unfettered, just like it would for any other citizen.
Right.
And that's what we wanted to make sure too, that there was nothing, you know, there were some questions that came up in the past about, well, does it have to go to our committee first before it can go to the AG and things of that nature? And an average citizen wouldn't be faced with that. So we wanted to make sure that that didn't occur again in the future.
Yeah.
All right, any other comments or discussions about 3185? All right, you're now looking at the drafted amendment to House 3184, which was combined by unanimous consent with 3185, offered by Representative McLeod, which I believe would require the new commission to provide to the Attorney General any complaint where they found willful conduct evidence of willful conduct on the part of the respondent when the violation occurred. Is that your amendment?
Yes, sir.
Does anybody have any questions about the amendment? All right. All in favor of adopting the amendment, raise your hand so we can record them. Aye. Opposed? Representative Smith, you're
I am opposed.
opposed. Thank you. All right, the pending question is adoption of House 3184 and 3185 as amended pursuant to House rules. We'll have a roll call vote
Bannister.
for favorable report, so yay.
Yay. Chairman Delaney. Representative Newton not voting. Representative James Smith.
Aye.
Representative McLeod.
Aye.
A vote of 4-0, the bill passes favorably as amended.
All right, the next bill on the agenda, and Representative Finley, you have both. Where'd you go? There you are. I thought my bifocals had kicked in. You got a lot closer all of a sudden. 3187, definition of committee. Tell us briefly, if you would, what you're doing.
Sure, and I do have to apologize. I've got a meeting that I've got to go to talk about the very important issue of dog driving in rural South Carolina. So I apologize. Briefly, 3187 is a bill that will amend two sections, 813, 1306, 23, 26, 23, and 32 by changing definitions of a committee, non-candidate committee, and a ballot measure, respectively, to include its main purpose of committee. I think we've all seen numerous attempts and campaigns to influence outcomes by outside money. This is part of what we're trying to get at here. It's a very complicated issue. always gives me great pain to admit this, but I believe Mr. Dennis will do a much better job of explaining the issue than I would. And on H 3188, we're working to amend 2 sections of code which limit and restrict campaign contribution and independent expenditures, including a prohibition on contributions to candidates from non-candidate committees directly or controlled by the candidates. Again, same thing, working on campaign contributions and working on campaign practices, trying to provide some better limits, wouldn't you say, Mr. Dennis? Yep, especially PACs.
Is it fair to say that 3188 is basically and getting rid of the PACs?
Yes, sir.
So the benefit of,
Now, of course,
no member can receive the benefit from a PAC. The PAC might still exist, but the ability to make contributions to a member goes away.
and when we say PACs, to the layman like me, we've got to be very careful because obviously we can't control federal PACs. We are simply talking about members of this body's PACs, as I understand it. The attempt to eliminate, basically we are eliminating those. There will be no more PACs run by members.
What's generally known as leadership PACs.
Yes, sir.
All right, any questions from the subcommittee on either 3187 or 3188? Does anyone who is currently present wish to be heard on 3187 or 3180? Representative Finley, thank you for being here. I know you have to go. Appreciate your sponsoring these bills and continuing to push the wagon of ethics reform.
Y'all.
Back to the question, now would be the time if anybody would like to be heard on either of those 2 bills. If not, any discussion from the subcommittee? So the bill before us is 3187, definition of committees. I think everybody on this committee is familiar with the lawsuit in the case that challenged our current statute, found to be unconstitutionally vague. This is the suggested language by the court that would allow us to have some ability to deal with those committees. Hearing that there's no discussion, pending question is favorable report of House Bill 3187. Roll call?
Well, Representative Bannister.
Yes.
Representative Delaney. Aye. Representative Newton is not voting. Representative James Smith.
Aye.
Representative McLeod.
Aye.
By a vote of 4 to nothing, the 3187 receives a favorable report.
All right, the next bill, 3188, campaign contributions from non-candidate committees. Are there any amendments or discussion by the subcommittee? Hearing none, the pending question is favorable report of House Bill 3188. Roll call as the rules require.
If I'm blinking or not here. Representative Bannister.
Yes.
Representative Delaney.
Aye.
Representative Newton is not voting. Representative James Smith.
Aye.
Representative McLeod.
Aye.
By a vote of 4 to 0, Bill 3188 receives a favorable report.
All right, there's no other bills on the agenda. It's unfortunate we had probably 30 more minutes we could have spent before somebody would have to leave. Having no other business, this committee's adjourned.